Story in our local paper this morning: as Missouri classrooms begin to fill in the pandemic, experts say lawsuits will follow. So, this is one of those questions that I've had all along when it comes to COVID. There's someone that is quoted in here. Susan Goldhammer, who is an attorney, says this is going to be a lawyer field day. I thought we'd call in Mark Cantor, Cantor Injury Law, who is a friend, fine sponsor of the program, to see what he thought about this. Mr. Cantor, good afternoon. How are you?
I'm great. Thanks for having me on.
Last time, I think we talked a little bit about, these lawsuits from maybe a business perspective, but is there potential liability here for students, or I guess for schools, if you will, if something happens at a school?
Cantor Injury Law is not accepting these cases. I think they're frivolous on their face, and, we're in this pandemic together. So I view that as an un-American cause of action. These schools, they can't win. They get sued if they open, and they get sued if they close. So we're not handling those cases. I don't think that it's going to be a field day for lawyers. This firm's not taking them because I don't think they're valid. And I think most juries would agree. You don't have a duty to warn of a danger when the injured party has actual knowledge of the danger. I mean, that would just be stupid. So, COVID is everywhere, and the parents know that, and these schools are giving people alternatives. So, from a jury perspective, and when we analyze cases, we say, what's a jury going to do? I don't like these cases. I don't think they're good. So every case is different. You could present a fact pattern that maybe I'd say, well, given those facts, if they knowingly or intentionally spread COVID, but I don't think that's going to happen.
Yeah, I mean, that would be one of those situations where, if someone, I don't even know what the scenario would be, but you've seen a couple of idiots out there who have on purposely coughed on other people or spit or something like that. I mean, that would maybe be something that would take a step or a leap into a different stratosphere here. But what the story said this morning is that most, and you can kind of verify this, so our school districts regularly shielded from a lot of lawsuits anyway, but there are some exceptions, or how does that typically work? And is it the same for like school districts, Mark, and also colleges and universities, or are those separate?
So great questions. There's something in the law called sovereign immunity. So sovereign immunity came from the British common law where you couldn't sue the king. In Missouri, we have sovereign immunity for public schools. So if you're talking about a public university or a public elementary school with public funds under 537.600 of the revised Missouri statutes, there is sovereign immunity. Now, there is an exception for premises liability. So schools can be sued for premises liability, but there's a whole series of case law that says, that obviously the plaintiff, the person that gets COVID, would have the burden of proof. So you'd have to prove that you got it from school, which will be a very difficult burden, and you'll have to get over the sovereign immunity. By the way, these schools are insured by something called MUSIC, the Missouri United School Insurance Company, and it's a not-for-profit insurance corporation. So it's like suing your church. I find it bad. I don't think it's in good form to sue a not-for-profit. That's not something Cantor Injury Law is interested in. And so you ask good questions. It's different if it's public versus private. A private institution doesn't have the same governmental protections. But, I'm frankly tired of everyone looking at the government as the source of either the problem or the solution. Everyone that's listening, everyone has a right to, keep your kid at home. And I'm not a scientist, but from what I've seen, the kids are recovering well from this if they even get it. So
that is true.
So I think it's time to open the schools. I'm personally at Cantor Injury Law. We got 7 lawyers. I've told my lawyers, we're not taking these cases based on generic facts. I don't think that they're valid. I think they're frivolous. I don't think it's going to be open the floodgates of litigation.
That's good to hear.
Yeah. So, if you get it's not like, so we're defining negligence, which is carelessness, right? So in a car accident, you have the duty to operate with the highest degree of care, that degree of care that a very careful person utilizes under the same or similar circumstance. It's different for premises liability. So you got to show, for the school to be negligent, maybe they're not following their protocols, okay, but it's got to be an egregious error. And then you still have to prove it came from school. So, frankly, I think that the concern is overblown. I think it's a good talking point, but again, I've been in the litigation business for 30 years, and these aren't cases I want because I don't find them to be valid. So
good information, and I'm with you on the schools. Mark Cantor, Cantor Injury Law. You can find him at cantorinjurylaw.com. Mark, always appreciate it. I appreciate coming on here this afternoon.
Thank you for having me. I appreciate it a lot. Talk to you soon.